Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the current status of a merger between Canadian communications giants Rogers and Shaw. The $26 billion deal, if approved, would be one of the biggest corporate mergers in Canada's history. The Shaw shareholders voted to approve the deal. The CRTC approved the transfer of the broadcasting license, but the Competition Bureau filed an application to block the merger, saying it would lessen competition in wireless services. On December 29th, the Competition Tribunal dismissed the Bureau's attempt to block the deal. The Bureau then announced it would appeal and obtained an emergency injunction that has stopped the deal from closing. What are the next steps in this historic merger? And if approved, what might it mean for the Canadian telecom industry and for Canadian consumers? We're joined today by lawyer Michael Binetti and Keldon Bester of the Canadian Anti-Monopoly Project. Thank you both so much for joining me today. Now, Michael, I gave a brief overview of what's happened so far. What can you add to the description? And I think for our viewers who might not be familiar with some of these basic concepts, what are the roles of the Competition Bureau and the Competition Tribunal in mergers like this?
Thanks for having me. I'll start with that last question. So the role of the Competition Bureau is to review these proposed mergers or transactions, as they sometimes call them. They're the government agency that acts as an enforcer, and they enforce something called the Competition Act. Then you've got the Competition Tribunal, which is a specialized court, and they're the ones who hear applications or challenges. And the person who challenges a merger is called the Commissioner of Competition, and he or she is the head of the Competition Bureau. So in this case, the Commissioner of Competition, or the Bureau, they challenged the merger between Rogers and Shaw. But in the end, as you alluded to, the Competition Tribunal heard a very fast-tracked case. It took about a month, and they got a decision out, I think, in 17 days. And they said, no, we don't have any competition concerns that competition will be lessened by this. We actually think this merger is going to increase competition, especially in wireless. And there was a bit of a fight over what transaction they were actually trying to review. But in the end, that's what the tribunal held, that it was good for competition.
Keldon, is there anything you want to add to that? And it certainly is surprising that a merger would add to competition. How did they reach that conclusion?
So the argument that the transaction is pro-competitive is that Shaw was in the process of exiting the wireless and wireline businesses, and so really wasn't up to it to make these investments it allegedly needed for to continue to offer wireless and next-gen wireless service. So Rogers has struck a deal with Videotron, a Quebec company, to effectively take over Shaw's wireless business and give it a number of favorable agreements for sort of the inputs to that business. So on the basis of that transaction and those agreements, the parties are arguing that this will actually enhance competition in Canada.
Now, Keldon, one of the things that stood out to me is that the challenge was to the wireless part of the merger, but these companies obviously have more than just wireless services. So should there be broader concerns about the merger, or really should we just be focused on the wireless implications?
Well, I think the wireless focus is a product of how our competition law works. It tends to focus on overlapping geographic markets. So when it came to Shaw's wireline subscription or wireline infrastructure, there was no overlap physically between Rogers' network, but I think that misses a big part of how competition works. It's not just what you have sort of available at your fingertips. It's what you see in other jurisdictions, what kind of services other players are providing, and what you demand of the companies you interact with. Shaw's cable business and home internet business introduced a number of innovations over the years that even players that were not necessarily in its own geographic market eventually followed on. So the wireless focus really is a product of how our competition law works, but I think a broader lens can be appropriate.
Now, Michael, we've only got 30 seconds left in this segment, so I'm going to pose the question to you, but you can answer it in the next segment. I want to understand how the review process works. Like, how do deals like this get reviewed, and what do the companies need to show in order for it to get approved? And you also alluded to the speed at which this happened. And I want to know, can you walk us through that review process and let us know the speed at which it happened? You said it was very fast, but is that speed unusual? We've got to go to break, but I look forward to hearing the answer when we come back. Welcome back to Canadian Justice, where we are discussing the Rogers and Shaw merger. Michael, in the last segment, I asked you if you could walk us through the review process for how deals like this get approved, and if the speed at which all of this happened, including the tribunal decision approving the deal, if that speed was unusual. What can you tell us?
So when transactions are big enough, and we're talking big, 90 million or larger, the law says you have to tell the Competition Bureau that you're proposing to merge. That starts a clock, and the Competition Bureau is allowed to ask you for information, and then they can look into the transaction. Really what they're trying to get to in a nutshell is this new company, or the post-merge company, is the fact that they've merged going to have a substantial lessening or prevention of competition. And you'll have to look at what market are you talking about, what product. So, in this case, they're talking about wireless. They were talking about Alberta and British Columbia. And what the Bureau is trying to see is, how much concentration is there going to be in that industry? What are the market shares, right? Is it just one player left? Are there two players? Is that going to make it harder for new companies to enter into this market, right? And so they call these the anti-competitive effects of the proposal. And then, so if the Bureau has a concern about what they say, for example, there's only going to be one wireless player left in this market, and they can charge whatever they want for wireless services, they would have a problem with that. And that could be in any industry. There's only one left, or there's only two left, and their market power is increased because there's fewer of them. So if they have that concern, what normally happens is they negotiate a remedy to say, well, you can't own all of this particular business in one area. You need to get rid of some of these stores, some of this product, some of these services. The other thing the Bureau can do is they can actually bring this application in the Competition Tribunal and challenge it and say, Tribunal, you can't let this go through. It's going to have such a negative effect on competition in this market. That's what happened. Now, the speed at which they had a trial and a decision is a bit unusual, because the tribunal really tried their best to accommodate this closing date that was supposed to be in early in 2023. And they really did bend over backwards to hear all the evidence and get a decision out. And I mean, kudos to all of the experts and the lawyers, because they managed to marshal a trial in very, very short order.
So, Keldon, this tribunal decision saying the merger can proceed, that is being appealed by the Bureau. What can we expect to hear at that appeal? And when is the appeal being heard? When's that taking place?
So the appeal is happening on Tuesday the 24th, and there's kind of four big grounds for the Bureau's appeal. I can try to summarize those. One, there was a fight, and Michael alluded to this earlier, over, what is the right transaction to be looking at? Are we looking at the Rogers-Shaw transaction and the Videotron deal as a remedy, or is it really the sort of Shaw-Videotron transaction that is not a remedy, but a sort of follow-on transaction? The Bureau thinks the tribunal erred in its consideration of that. Second, it suggests that the tribunal didn't give enough reasoning for why its approach would not have affected the outcome as it alleges. Third, they argue that the tribunal did not appropriately consider the price effects that would arise from the merger, sort of their scope, their duration, even the Videotron deal. And finally, and I think most interesting from at least from my perspective, is the nature of these contracts between Rogers and Videotron. The Bureau is saying that it was inappropriate for the tribunal to include those as part of the deal.
Michael, is there anything you want to add about what to expect at the appeal?
Along the lines of Keldon, they're saying what the Bureau said was you need to look at the original deal that included Rogers acquiring Freedom Mobile through Shaw. But by the time the hearing happened, Shaw had agreed to jettison Freedom to Videotron. And what was very interesting, the outcome, the tribunal says, and this will be up for appeal, the tribunal says, well, it doesn't really matter because we say there's going to be more competition. So whether or not it's a remedy or whether we should be looking at this transaction really doesn't matter, because we need to look at what's going to actually happen tomorrow. And that is Freedom Mobile going over to Videotron. And the weight of that finding kind of overtook every other argument as to, well, what deal are we arguing over?
Right. When we come back from this break, I want to talk about the broader implications of this transaction on consumers. We'll be right back. Welcome back to Canadian Justice, where we're talking about the Rogers-Shaw merger. Keldon, I think the big question a lot of Canadians have is how this deal might affect them as consumers. I mean, we know that the Bureau has their opinion, the tribunal has issued their opinion. What is your opinion? How is this deal going to affect consumers?
Well, I think there's a lot of risk here that consumers are, certainly not made better off and potentially worse off. It really hinges on, does Videotron make good on its, I would say commitments, but its message that it is ready to be a, disruptive competitor in the wireless space. We are, no matter what, we are losing a source of potential competition in Canada with the removal of Shaw. And so future expansion that could have occurred on both sides is now sort of a foregone conclusion with them exiting the market. So, Videotron has been a strong competitor in Quebec. But the big question is, especially with these agreements it's entered into with Rogers, is it going to replicate that performance? And, is Rogers really willing to create a disruptive competitor for itself?
Michael, same question to you. We know what the tribunal thinks. We know what Keldon thinks and what the Bureau thinks. What's your view on how this might affect competition in Canada in the telecom industry and the wireless industry?
Well, to my mind, one of the longer term questions, which Keldon alluded to, was whether Shaw, I mean, we accept that Shaw says that they didn't have the ability to turn Freedom into something more. So if Freedom as owned by Shaw was just going to left to wither on the vine, then to my mind, the question is, well, is it just a matter of timing? Is the loss of this player going to be felt eventually? Right. And so if that's the question, is there another way to have competition that doesn't require an exact copy of the business model of Bell, Rogers, and Telus? Right. And can having that Videotron piggybacking Freedom onto the other network, onto Rogers network, can that drive prices down? I mean, that remains to be seen, but I think that's the only way there can be a positive impact for consumers at this point.
Keldon, can you give me a sense of whether or not the telecom industry has a competition problem relative to other countries? Because I certainly think that has been a lot of the discussion publicly around this merger. It's the sense among a lot of Canadians that we have very high prices for telecom services. But I'd love to hear an expert opinion about whether that perception is accurate.
Well, I think that perception is backed up by a lot of evidence, both quantitative data and just the sort of anecdotal experiences when Canadians go abroad or when international individuals come and live in Canada and sort of run face first into our telecom oligopoly. So we definitely do have a competition issue, and we continue to sort of struggle to address that issue. And I think building on Michael's point, the question now going forward is to say, in this new environment, what is the right approach to not just competition policy, but in particular telecom policy that can actually deliver benefits to Canadians when there is, and it's unsurprisingly a very contested point, but quite a bit of evidence that we pay globally much higher than peer jurisdictions.
Michael, the companies have said that in order, in part, to protect consumers, that they're not going to be increasing prices for a set period for three years after the deal. Are there any other promises being made to consumers? And what about after those 3 years? Will this, is this going to have a long-term impact on competition, even if in the 3 years there's this hold on the prices?
And I think to step back, as it ended, right? Well, I'll start with the end. The Videotron prices were about 20% lower in Quebec, or the average price in Quebec. And I think Minister Champagne said he wouldn't transfer the spectrum licenses over unless they had prices that were equal to that. And the companies agreed to that. So it started out with this vague promise that they were going to hold prices in 3 years, but in the end, I think the divestiture deal that sees Freedom go to Videotron, at least in the short term, is going to be better. But after that, there's been recurring problems in Canada where, well, I don't know if it's a problem, but what happens is promises are made, they are kept, but then after that period expands, then sometimes the wireless spectrum just goes back to the incumbent or goes to one of the other big three. So it's pretty hard to enforce after these deals expire. But while they make a commitment, sometimes they get turned into a court order.
Right. So
and those are enforceable.
We've got to go to break now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the Rogers and Shaw merger. Now, Michael, there is going to be a House of Commons Standing Committee on Industry and Technology that's going to be holding meetings to review the updated deal. Now, the committee doesn't have the power to block the merger, so what exactly are they going to be doing, and what can they do?
They can hold a meeting. They can invite witnesses to come and testify. Some of those may be industry experts, stakeholders, and they can bring more visibility to some of the more minor issues or major issues. They can come out with a report. The Minister Champagne can review that report and ultimately decide whether or not he's satisfied to transfer the wireless spectrum licenses. But there's not a whole lot that these parties can do to actually block a merger.
Keldon, anything that you want to add there on the parliamentary processes, and what are the powers of the minister to impact the merger? I know some of our viewers might be familiar with a transaction involving Canadian Potash that was blocked by the Minister of Industry. How is this different?
So the minister has powers under the Investment Canada Act with regards to sort of foreign investment and foreign takeovers under broadly a national security.
The potash transaction was a foreign purchase. This is domestic.
Domestically, his role is really limited to, in this case and in all cases, the transfer of wireless spectrum, which is a key input to offering wireless service. So, he does have, I think, quite a bit of informal sway over the transaction, but ultimately the only assets that he can speak for are those spectrum licenses. And thinking about the committee, I think this committee has done great work, raising the profile and bringing additional voices of the public to the conversation. And I would hope that this committee meeting is one input into the minister's decision-making regarding those spectrum assets.
Michael, what can you tell me about other large transactions where the government has blocked mergers? Has that ever happened? Has there been something where something like the spectrum wasn't transferred because the minister stopped it? I gave the potash example, which was because it was a foreign transaction, but are there any other examples?
Domestically, it's hard unless you have a hook like we have in this case where the discretion vests completely in the minister for spectrum licenses. But if these were two storage companies that were only based in one province, it's very little. And the other problem is the bureau, the Competition Bureau, which admittedly is not the government, it's an agency. They haven't won a contested merger after a trial, but the vast majority, like I think since in the last 10 or 12 years, there's been like 60-ish negotiated public settlements. So they're very effective at negotiating terms where they'll agree not to proceed with a challenge of a merger as long as the companies do X, Y, and Z. And that's usually what happens. Very infrequently do you have a contested trial, and those usually end in the merger going ahead. So it's not it's pretty infrequent that the tribunal blocks a merger.
Keldon, we've only got about a minute left, but in that time, can you really briefly tell us how does Canada compare to other countries with our competition law? If hypothetically this merger were to take place in the United States, would it be approved there? And can we even make that comparison?
We can always compare. It would be a toss up in the States. So the thing to reach for would be T-Mobile's purchase of Sprint a number of years ago, which was eventually approved, although challenged. The U.S. is going through a big upheaval that is taking a look at the past 40, 50 years of treating mergers quite laxly and saying, well, what do we get for that? And often where they're finding high levels of concentration, high prices, and reduced consumer choice. So, Canada is quite weak when it comes to merger law. And I think the big open question is, following jurisdictions like the United States, like the European Union, do we get our act together and
Keldon,
start taking these things more seriously?
That's all the time we have, but thank you both for coming on.
Thank you.
As the Rogers-Shaw merger gets closer to approval, many consumers are left asking what the consolidation of the industry will mean for prices. With fewer competitors, will prices go up and leave consumers worse off? You be the judge. I'm Christine, and remember, a freer Canada starts with you.